Hello and welcome. I'm Anand Naidu sitting in for Riz Khan. Should the American government have the right to tap into citizens' phone conversations and read their emails without a court order? And should the phone companies that make this possible be given immunity from any lawsuits? That's the debate that's been raging in the United States for the past 2 years. It started when the New York Times revealed more than 2 years ago that President Bush had secretly authorized the National Security Agency to eavesdrop on Americans to search for evidence of terrorist activity. That type of surveillance normally requires a court-ordered warrant. As we mentioned, the program depends heavily on the big telephone companies. Warrantless wiretapping, as it became known, was enshrined in law, the Protect America Act. But that law expired this month, and so far the Democratic-controlled House of Representatives has refused to renew it. The president has been urging Congress to do so, most recently this past Monday.
To put it bluntly, if the enemy is calling to America, we really need to know what they're saying. And we need to know what they're thinking. And we need to know who they're talking to.
So how much power should a government have to spy on its residents, especially in a time of war? Don't forget, we take your calls on the show. You can reach us at the numbers there at the bottom of your screen. Now, joining us today are Michael German, a lawyer who works at the Washington office of the American Civil Liberties Union. He is a 16-year veteran of the FBI, where he served as a special agent on domestic terrorism. And Kamal Nawash, a Palestinian-American lawyer who founded the Free Muslims Coalition in 2004. He is fiercely critical of many mainstream Muslim organizations in the United States, accusing them of not speaking out against terror. Gentlemen, thanks for joining us. Michael, let me start with you. The ACLU, the American Civil Liberties Union, is opposed to the extension of this law. Why?
Because we have a Fourth Amendment in this country, which says that if the government wants to have access to your personal documents, your personal space, or your telephone calls, they need probable cause and a judicially authorized warrant.
And none of it is provided for in this extension?
In the Protect America Act, there aren't individual warrants required, no. And so that's why we were against that law and celebrated its expiration and don't believe it should be extended. We have the Foreign Intelligence Surveillance Court, which, as the president says, if the enemy is calling into the United States, all the government has to do is go to a court and show the probable cause to believe that this person is the enemy, and they should be able to listen to that call as much as they are authorized to by the court. But what we're against is the government saying that we can listen to anybody who calls into the United States or anybody who calls from the United States.
Well, Kamal, getting a court order to eavesdrop on people's conversations, that sounds pretty reasonable, doesn't it?
Sure, it does. And you know, one of the difficulties with giving an opinion on this particular case is there's so much we really don't know. We don't know why the government wants this. We don't really know why the traditional approach, such as what my colleague suggested, following the Fourth Amendment and getting a court order, why that's not sufficient. That's what makes it difficult for someone like me to just come out directly against the government and say it's wrong. Now, obviously, like my colleague, you know, no one wants to be spied on, for sure. But this law came out, or when President Bush authorized the NSA to do these surveillance acts after September 11, because they felt there was a need, that there was exigency, there was an emergency situation that we cannot use the traditional methods to follow. I'm saying before we completely say, hey, that's wrong, you can't do this, we need to know why is it that the government cannot follow the traditional approach, why they can't go into a regular court. Now the government says, hey, there's not enough time for that. Well, if that is the case, if we don't have enough time to follow the traditional approach, maybe we can work with the government and come out with a middle ground that protects American citizens' rights, at the same time not hinder law enforcement's ability to pursue.
But isn't there a fear, and the reason I would assume the courts are involved in this, isn't there a fear that a system like that could be abused?
Well, there's always a fear, yeah, absolutely, and that's why our forefathers enacted the Fourth Amendment to begin with, to protect our rights. And certainly, the Fourth Amendment is something I'm very proud of, and I'm very proud of the fact that the U.S. is one of the few countries on earth that protects us. We wouldn't be having this conversation in most parts of the world. But the fact is, we did have a September 11. There are people out there that do want to attack the United States, and the United States, whether rightly or wrongly, and this is the problem, is I can't judge whether it is rightly or wrongly, feels that they need to have this non-traditional approach to listen in on citizens. And so I think probably the next step, before we decide conclusively, we need to find out why the government cannot follow the traditional approach, and maybe we can do an analysis at that point.
And that would be something that we would support. I mean, one of the things we've been against from the beginning is Congress legislating in the dark on this issue. And there hasn't been enough information known about exactly what's happened. And certainly when you talk about giving immunity out, that's a very permanent sort of change in the law. And to do that without knowing what laws have been broken is extraordinarily premature and
you know, he
dangerous.
did mention one point, and you mentioned something in the introduction that I want to comment on. There's a substantial difference between allowing the government to do this and giving immunity to private telephone companies. Now, while I'm willing to give the government some slack, to give them some extra room to maneuver, I certainly would not want to give immunity to private companies.
Yes, but
that's
the government
completely
says
different.
it wouldn't be able to do its job properly if they don't get the cooperation of the telephone companies, which is basically supplying this raw data, isn't it?
Well, it's not just raw data, it's access to the communications networks.
Right.
And one of the things to remember about this is that when they created the Foreign Intelligence Surveillance Act in the first place, back in 1978, when the first set of wholesale spying was discovered, the purpose of the Foreign Intelligence Surveillance Act was to provide the telecoms with certainty that when you get a court order, you know that you are protected. So you should not give information to the government absent a court order. So they knew the law when they chose to comply with the government's request to operate outside the law. So again, you know, the extent of that cooperation is still unknown. And one of the things we should do is Congress should get to the bottom of exactly what happened.
So when the Bush administration embarked on a system of tapping telephones without court-ordered warrants, were they breaking the law?
Absolutely. They were breaking the Foreign Intelligence Surveillance Act and violating the Fourth Amendment. And one of the things to keep in mind, too, they've often talked about this as a modernization, but they asked Congress to amend the Foreign Intelligence Surveillance Act several times since 9/11. And Congress has acquiesced, and in the Patriot Act, they changed it, and many other times. And so they could have come if they felt they needed extra authority to the Congress and asked
But
for
at the
it.
same time, you really can't say that they were breaking the law unless a court says they were breaking the law. I mean, this is what the fight is about. I mean, we have one court, a district court, that said, yes, this is unconstitutional. We have a court that's higher than that says, no, maybe it's not. And the Supreme Court recently refused to hear the case. So deciding whether it's constitutional or not, or whether it's legal or not, it's not something clear-cut that you and I can say. That a court needs to come in and say, hey, it's illegal.
Just to correct you, the appeals court on that case didn't say that. They said the plaintiffs don't have standing because they can't prove that they have been wiretapped, which is sort of the catch-22 in this, that somebody who can prove that they've been wiretapped, that evidence is classified and therefore can't be
But I'm
used.
saying you must agree that you know, something is not unconstitutional unless a court says it is unconstitutional. You and I can't come and say, hey, it's illegal or legal or constitutional or not. That's why we have a Supreme Court that has the final say-so in this and decides what's constitutional or not. We can give our opinions, but it's got to be an opinion. You got to make that clear.
I don't think that's true. I mean, the law is very clear. The Foreign Intelligence Surveillance Act said this is the exclusive means for domestic surveillance. So to engage in domestic surveillance without going through the Foreign Intelligence Surveillance Court process is a violation of the law. And certainly it would take a judge to say that somebody violated that and should be held responsible and go to jail. That would require.
But I think also the FISA, the Foreign Surveillance Act, wasn't it when it was enacted? That's when the government specifically wanted to wiretap the telephone calls of Americans. In this situation, I'm sorry, go ahead. We don't want to take your show from you.
No, it's fine. No. This goes to an email which we received just a short while ago. What you're talking about. This is an email from Paul C. here in the United States. He just signed himself as Paul C. And it says, Bush has used the Protect America Act to spy on anti-war people, nothing else. Now, we don't know that.
We don't know that. That's the point.
But it can happen. Right?
Well, if it is, and that's what I'm saying. I'm not willing, like my colleague, to take a conclusive position. I'm saying here we have a situation where we don't know anything. We have the government that's telling us they need the ability to do this, and they're saying the traditional way doesn't work. I don't know what they're doing. I don't know why they're not. I think before, certainly we have to give the government some discretion in light of September 11.
Michael's point was that the old way did work.
Right. And not only did it work, I mean, for 30 years it protected us during the Cold War when we had nuclear bombs, hundreds of them aimed at us. The Foreign Intelligence Surveillance Act was robust enough to protect us. If there were amendments that needed to be made when the administration made its case to Congress, those amendments were allowed. And that it did this absent any sort of public discussion, I think reveals that they knew that what they wanted to do was not something that Congress or the American public would accept.
Yeah, but you had, for years, Congress did not interject. They did not interfere, and they didn't tell the government, no, you can't do this.
Well, let's look at the original reason why the FISA Act was introduced. Wasn't it introduced because of political abuse?
Absolutely. And it goes back to the post-Watergate era when Congress, through the Church and Pike committees, did investigations of the intelligence community, and they found that the FBI engaged in illegal surveillance activities through its COINTELPRO program, that the NSA engaged in a program called Shamrock, in which they indiscriminately seized and read the communications of Americans that were going overseas and coming in from abroad. And the public said, we don't want that. We do want a system. And the telecommunications companies also wanted some comfort that, hey, when the government comes to us and says we need something, we don't have any way to evaluate that request. So we need a law that says, you have to comply with this law when a court reviews the evidence and sees that there is enough probable cause. And that system has protected us for over 30 years.
Okay, we have another email here from Michael, also in the United States, and he says, who needs to spy on terrorists when you have the Democrats led by the leftists in both houses of Congress? They're supporting the terrorists and sabotaging the American mission and troops right out in the open.
There you go. He has a great point.
I mean, I was in the FBI for 16 years. Believe me, I am all in favor of getting the terrorists, but you don't get the terrorists by doing a dragnet. Getting your telephone calls is not going to help stop terrorists. Getting mine won't help stop terrorists. Getting yours won't help. If you're grabbing the calls of innocent people, that is just accumulated waste that's going to clog up.
No, Mr. Chairman, no one disagrees with what you're saying.
But listen,
I don't disagree with that. I'm just saying, and I thought we both agreed on this, is that the government is saying, hey, they need these extra powers. I don't know that they do or don't. I think probably the next step, before we say they cannot do this, in light of September 11, in light of the various terrorist acts, we should at least put them to the question, why do you need this? Why is it that the traditional approach, FISA, does not work? And that's what, in my opinion, has not happened. Right. That's what we haven't done a sufficient amount of, putting them to the fire, telling them, well, why can't the traditional approach work? I mean, you're telling me why you think it can, but I want to hear from the government why they think they can't do it.
And that's fine, but in a country that is ruled by the rule of law, you don't do it and then ask for permission.
That's fine.
That conversation should have happened back in 2001, and that they did it in violation of the law, I think puts the onus on them, not on the rest of us.
Fair.
But the point of the Fourth Amendment is that it's there to focus the government on people they have reason to believe have done something wrong. So if we take imagine how.
Oh, but remember, this is they're saying they are doing this in this situation, that they are focusing on certain people outside the country who they think are terrorists or who they think are doing something wrong, and it just happens that these people that they say they are legitimately focusing on are calling Americans, and they're saying, well, while pursuing people that they believe they are legitimately pursuing, it just happens that they end up talking to Americans. They say, well, we can't miss this conversation. This is what the American government is saying, and this is the difference.
There is a 72-hour leeway that the
and we want to know why isn't that good enough for the government. I want to know that.
They don't have to go to the court immediately. They can wiretap these conversations, and then they can get a warrant in 72 hours.
Absolutely. And one thing to keep in mind is probable cause is a very low legal standard. So if they have reason to believe this person is a terrorist, if they write down what that reason is and bring it to a court, a reasonable judge will say, well, if it convinced a reasonable intelligence officer, most likely it'll convince a reasonable judge as well. So it is a very low standard, and that they're completely abolishing that standard tells me that they don't really have reason to believe that these people are doing anything wrong, that they want to seize.
And that may be correct.
Because the courts have generally been very, very cooperative in this the majority of...
Well, yeah, in FISA cases in particular,
Yeah.
I think they generally rubber stamp these requests. They rarely say no to them, if I may be correct.
Right. I mean, they have somewhere around
So doesn't that
30,000.
raise the question, why is the government so insistent that it be able to do this without...
And I want to know that. And if they give me a reason that it's insufficient, that doesn't pass the smell test, that just that's just completely unreasonable, then yeah, I would be the first one saying, hey, the government, you can't do that. You absolutely can't do this. But at least in light of September 11, I want to at least give them some benefit of the doubt until they give me a reason. And I think your effort and my effort and the effort of Congress should be asking the government, why is it that the traditional approach can't work? Maybe there is something that is about the traditional approach that doesn't work. Maybe we need to make some changes in the law. And that's all I'm saying.
Well, there's another email here, Mr. Nawash. It says, how does it feel to advocate the sacrifice of our rights to your fear?
It does not feel good, but he's making an assumption that I want to sacrifice our rights. I'm not saying I want to do that. All I'm saying is that, we do have a Fourth Amendment, and I'll probably be one of the first ones to defend it before you do. I think it's one of the great hallmarks of this country. I certainly live in America. I have an option to live in other places, and it's because of our Constitution. But we did have, law enforcement do need certain tools to prevent things like September 11. And if law enforcement tells us that the traditional approach doesn't work, I want to know why. And if it's true that it doesn't work, I want to make some changes in the law to help them out. That's all I'm saying. And I'm not willing to make a decision one way or the other.
And one of the things to consider too is that type of oversight, I think, needs to be done on a broad scale.
Yeah.
I mean, one of the things that was frustrating to me, the week that the Protect America Act passed in Congress, there was a Newsweek article that referred to the National Security Agency having periodic power failures due to an antiquated electrical system in their compound there. And now that is something that's a real problem. And if the administration often refers to an intelligence gap, I would say if the power's out, that's going to create an intelligence gap. And it's that type of mismanagement that Congress really needs to dig into, rather than just blindly giving these agencies more authority.
And we have had some pretty egregious mistakes in security legislation when Ted Kennedy gets put on the no-fly list.
Absolutely, and that's part of that. That's what happens when you do these dragnet sort of security programs, where you're gathering information about innocent people. You're obviously going to implicate the rights of innocent people.
Gentlemen, we're going to have to leave it there. We've run out of time. Thank you very much for joining us.
Thank you.
Interesting debate. No doubt we'll hear much more about it.
Thank you.
Thank you. And thank you for being with us. On the next show, we speak with Kareem Rashid, the revolutionary Anglo-Egyptian designer who's changed how we look at everything from our watches to our furniture. Don't forget, if you have any thoughts about pressing issues around the world, send us your emails to riz@aljazeera.net. See you next time. Street Talk is next.